podcast published by the Meritas EMEA Employment Group. Periodically, members of our practice group get together to discuss interesting and topical cross-border issues. Meritas is a global alliance of leading independent law firms dedicated to helping clients access top-tier legal expertise from anywhere in the world. I'm Sam Murray-Hind, a lawyer at the law firm Howard Kennedy in London. I also head up the Meritas EMEA Employment Group. Welcome to today's episode. Today, I'm joined by Diana Rodriguez from Marimon in Spain, Sabina Taxa from Vengavielli in Switzerland, and Sofia Kizantidi from Symbanoulis in Greece. All are employment lawyers and specialists. Our discussion today is on remote working, which moved into the spotlight during the pandemic with people either stranded abroad or choosing to travel to sunnier climes to work from there, with or without their employer's knowledge in some cases. This scenario requires the employer to look at the position in both the home country and the host country. I wanted to be clear that we're not dealing with the Posted Workers Directive today, which applies to EU member states. And that's where a worker is employed by a company in one member state, but they're posted to a company in another member state. And in that case, there must be a contract in place between those two companies. But I mention it here as it's a relevant consideration and listeners may want to seek advice from their Meritas member firm on this particular aspect. From a UK perspective, and because of Brexit, the Posted Workers Directive doesn't apply to workers posted to the EU from the UK or vice versa. Now back to remote working. As the practical considerations are substantially the same for each jurisdiction, I think it's a good idea to perhaps break this topic down into the different elements that an employer needs to look at. Now, Sabina, you're going to talk to us today about the applicable laws. And it's the case that employers need to look at both the governing law clause in the contract and also whether mandatory local laws may apply to the employment relationship. So if an employee of an international company works remotely from Switzerland, which country's employment laws would apply?
That depends on several factors. If the employment contract includes a choice of law clause, so the selected law generally governs the employment relationship and also the employment contract. However, under Article 121, Para 3 of the Swiss Federal Act on Private International Conflict of Laws, the parties cannot freely choose just any foreign law. They must select a law that has a legitimate connection to the employment relationship. So the parties may subject the contract of employment to the law of the country in which the employee has his usual place of residence, or in which the employer has his place of business or his registered domicile, in the case when the employer is a company, or also of his usual place of residence when the employer is an individual person. And additionally, and irrespective of the choice of foreign law, Swiss mandatory employment law provisions may still apply if the employee is physically working in Switzerland. This is relevant regardless of the employer's location of its business offices. Most important are the mandatory Swiss employment law provisions aiming to protect the safety and the health of the employee. So mandatory employment protection regulations cover, among other things, working hours and breaks, special protection for young employees and pregnant women, minimum vacation entitlements, termination protection, and health and safety regulations in Switzerland.
So in terms of choice of law under the contract, even where a foreign law is provided, then Swiss law could still apply?
Exactly. Under our International Private Conflict of Laws Code principles, mandatory Swiss employment law provisions apply if the employee usually carries out their work in Switzerland. This means that the employee cannot waive rights such as protection against unfair dismissal or statutory vacation entitlements under Swiss law, even if the contract stipulates a different governing law.
So what if the contract doesn't have this choice of law clause?
In the absence of such a choice of law clause, in Article 121, Para 1 of our Swiss Federal Act on Private International Conflict of Laws determines the applicable law based on where the employee usually performs their work. If the employee works primarily in Switzerland, Swiss law will generally apply, even if the employer is based abroad. This principle ensures that the employees are not deprived of the protections granted by the country in which they habitually work. It is crucial for companies to be aware of this when engaging remote workers.
And what about the employer's obligation? So if the company is based outside of Switzerland, does that affect its legal responsibilities?
Yes, exactly, it does. A foreign employer without a Swiss presence in Switzerland may still be bound by Swiss employment laws concerning employee protection. They must ensure compliance with Swiss mandatory employment provisions, even if they are not registered in Switzerland. While certain obligations such as social security contribution and taxations are important, those will also covered separately in this podcast by my colleagues.
So if we flip this scenario, so can a remote worker in Switzerland be required to follow all the employment laws of the employer's home country?
Not necessarily. Even if a contract specifies foreign law, Swiss courts will apply overriding mandatory provisions of Swiss employment law to protect employees working in Switzerland. This means that local working conditions, dismissal rules, and certain financial entitlements remain applicable, no matter what the contract states.
And if a company wants to try and avoid those compliance issues, what would they do?
Yes, that's a very important question. Companies should first ensure their employment contracts clearly define the governing law while acknowledging the applicability of Swiss mandatory employment provisions. They should also stay informed about employment law developments in Switzerland to ensure compliance with local regulations. Seeking legal advice before allowing remote work from Switzerland can help to mitigate risks for the employer.
Thanks, Sabina. That's really helpful. Do you have any final thoughts around choice of law?
Yes, in my opinion, remote work brings great flexibility to employers in international companies abroad, but the companies must be aware of the legal implications. Understanding the applicable employment law frameworks helps avoid unexpected legal issues and ensures compliance with Swiss employment laws.
Thank you. We're now going to switch to a different consideration that employers need to look at. And I'm going to ask Deanna just to give us a high-level introduction into this issue and the arrangements in place between EU member states.
Yes, thank you. It is obvious that international teleworking has experienced significant growth in recent years. Just as with the law applicable to the employment contract that Sabine has just explained, this new reality poses a challenge to existing social security regulations as their provisions do not adapt to this new reality. As a general rule, the employee is subject to the legislation of the country in which they provide services. Sorry, I will read that. As a general rule, the employee is subject to the legislation of the country in which they provide services. What used to happen was that the country where the employee provided services was the same country as their country of residence. But with remote working, this is no longer the case. Let's take an example. An employee who resides in Spain provides services under a teleworking agreement for a Greek company, and this company has no interest or industrial or commercial relations in Spain. So according to traditional legislation, the employee should be subject to Spanish social security legislation. However, for this to happen, the company must register as an employer in Spain, obtain a tax identification number, pay the Spanish social security contributions, and submit the withholding taxes for the employee's salary to the Spanish tax authorities. And this is something that normally companies that were involved in the employee's choice of residence do not like. They are concerned that their exposure to the tax and social security authorities of another country could cause them problems. It is particularly worrying that the authorities in the employee's country of residence might interpret this as the employer company having a permanent establishment in the employee's country of residence for tax purposes. While this is usually not the case, it certainly causes discomfort and concern among companies, and my colleague will talk about this later. So until now, the only regulations we had were the bilateral agreements of Social Security, and for the European Union countries, the EU regulations, which provide that in the case of temporary displacement from one state to another, Social Security can remain in the country of origin under certain requirements, circumstances, and for a limited time. However, in the case of international telework, whether temporary or permanent, there is no intent by the employer to transfer an employee, but rather the employee decides to relocate the residence, or the employer hires someone who is already residing in another country from the start, as you said. So the general rule that will still apply will be that the employee will be subject to the legislation of the country in which they reside. Regarding the European Union countries, on July 2023, a framework agreement was approved on habitual cross-border telework. And this framework agreement allows for exception to the general rule that tele-employees are subject to this legislation of their country of residence, and allows parties to request that the employee can be subject to the social security system of the employer's country, employers, not the employee, provided that teleworking in the country of residence does not exceed 50% of the total working time. I mean, if the employee works remotely less than 50% in their country of residence, the employer can ask for the employee being subject to the country in which the employer has their work center. So this framework agreement came into force in July 1st, 2023, and has an initial validity period for 5 years until 2028. But as I said, this will be only for European countries pertaining to the European Union. But for the rest of the countries, I'm afraid that we will still have to apply the general rule of residence of the employee, or if should be the case, it may be applicable, look into the bilateral agreements of the countries involved.
Yeah, you can see why the framework agreement came around, and also how this is such a developing area, given that there's so much more global mobility. I thought it might be helpful just to quickly say something about the UK position because of Brexit. So there is social security coordination between the UK and EU member states, and that's continuing under the Social Security Protocol, which is attached to the UK-EU Trade and Cooperation Agreement. So that applies to those who are or have been subject to EU or UK legislation. And where a person is covered by that protocol, they are only subject to the legislation of one state, subject to certain exceptions. And the main exceptions are for short-term assignments or where someone's working in 2 or more states. And that's the state in which those employment activities are being performed. So if you've got someone working in 2 or more states, then they're subject to contributions in the member state in which they reside, provided, as Diana said, that the substantial amount of activity is taking place, and the threshold there is more than 25%. The only other point that I wanted to make is about the UK NHS. So on the health side, access to the NHS is dependent on residency. And if you're not resident here in the UK, then you're treated as a visitor when you're using its services. So thank you, Diana, for that element. Moving on to our last speaker, Sophia. I wondered if you could talk to us about the risks of creating a permanent establishment. So that's been mentioned already on this podcast. So if you could just give us a sort of high-level introduction into this and the sort of things that people should be thinking about.
Hello, Sam, from me as well. Greece has also adopted the necessary legal framework to facilitate remote working. Given the enormous expansion of electronic means, more and more employers embrace it. As a result, both legal and practical issues related to remote working have become a pressing concern. Practice has shown that in several cases, employers view the option of allowing their employees to work from outside their traditional offices or while traveling as a perk. Jobs in software development, graphic design, and digital marketing are popular for remote working. This applies also in customer service. For employees coming from abroad to work remotely in Greece, either alone or in groups, the employers confront with the question within which framework their employees may carry out their activities, and under which circumstances those employees residing in Greece for shorter or longer periods need to adjust their employment agreements to Greek law. Legal assistance may be required in several cases. One aspect to be considered is if there are indications that a new establishment in Greece is being created from a tax law perspective. Having people working for you from Greece and carrying out exclusively preparatory or auxiliary operations on behalf of the employer may not be regarded itself as a permanent establishment. In any case, the exact facts and details have to be examined. If no income is generated from the business carried out in Greece, then in principle there is no permanent establishment. But even with those several criteria, some cases remain blurry and need further investigation. The answer to that question is closely connected to the social security contributions that have to be paid or not to the social security fund called IEFCA. Some of the businesses also approach remote working as a package to be included in the well-being work-life balance of their employees, sending them away for long or short-term periods. So I would repeat that all the above criteria should be taken into account before coming to a final decision about establishing or not a permanent establishment here in Greece.
Thank you, Sophia. I think this is an area which has been discussed a lot when we have our in-person Employment Meritas group meetings, and there's been real collaboration within the group in providing advice for clients on these issues. So to finish on a practical note and to take from our discussions today, employers in these situations should be considering introducing a global remote working policy. If there is a policy in place, does it need reviewing and updating? Have you got sections on working abroad? Some companies do allow employees to work abroad, but limit this to a certain period for specific reasons. Ensuring employees are aware that prior approval is needed if they're seeking to work abroad. The issues we've raised today include issues around jurisdiction and applicable laws, HR side of things. You've also got tax and immigration, as well as the permanent establishment implications that Sophia has just covered. And any regulatory or compliance restrictions on the employee's role from being done from overseas. So that could bring in considerations around tax, data protection, data transfer issues, as well as security and confidential information. And that brings us to the end of our episode today. But if any of our listeners have any questions or comments on this subject, do please get in touch with your Meritas contact firm. We'd be very happy to continue the discussions. Or if you would like to find out more about Meritas, you can do so via the website meritas.org. And that just leaves me to thank Diana, Sabina and Sophia for joining me today, and we hope you'll tune in next time. Thank you.
Thank you.
Thank you.